Greetings and welcome to the Quarles Brady LLP webinar 2018 Year Review, Recent Midwest Legal Decisions Impacting Real Estate and Construction Law. My name is Mike McCants and I am the co-chair of the firm's Real Estate and Construction Litigation Group. I am out of our firm's Phoenix office. Our team advises large and small businesses across the country on all aspects of real estate and construction law. I am co-presenting today with Charles Harper from our Chicago office, Corey Newmeyer here with me in Phoenix, Natalie Thomas from the firm's Tampa office, and Eric Van Scandal from our Milwaukee office. We are pleased to be with you today. I have just a few housekeeping items to go over before we begin the presentation. You may access a copy of today's presentation and other forms and materials in the handouts panel of the webinar dashboard. We will be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for today's program, please fill out the CLE form found in the handouts on the dashboard and return as directed. HR professionals will also find attendance certificates for today's webinar in the handouts provided on the dashboard. We have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. Please be aware that we are recording this presentation and an electronic survey will be emailed to you after the program. If you have a question during the presentation, please type your question in the Q&A box located in the upper right-hand corner of the webinar dashboard and submit. The conference host will make sure the speakers receive the message. Every effort will be made to answer the questions in the final minutes of our time together today. And with that, I'll turn it over to Charles Harper in Chicago, who is going to discuss mechanics liens. Charles?
Hi, thank you, Michael. Welcome, everyone. I'm Charles Harper, and I'm a commercial litigator in the Chicago office with a focus on real estate and construction law, and I will be talking about updates in the Midwest on mechanics liens. And we're going to start today in Illinois with what sounds like the setup to a bad joke. An interior designer walks into a county recorder's office in Illinois with a mechanics lien. Is this a valid lien? And the punchline is yes, this is a valid lien. Effective January 1, 2019, the Illinois Mechanics Lien Act now expressly includes registered interior designers among the persons entitled to record a lien when they are not paid for their work to improve a property. The new law passed by the legislature in 2018, in addition to making amendments to the statutes relating to the registration of interior designers, also amended Section 1 of the Mechanics Lien Act to add registered interior designers as persons who may record a lien for services to improve real property in Illinois. So now registered interior designers are alongside the other enumerated professionals in the Act, such as architects, structural engineers, professional engineers, land surveyors, and property managers. Because this change came about in conjunction with the registration rules for interior designers, presumably the courts are going to be looking for an interior designer enforcing the lien to be an actual registered interior designer in Illinois. Our next question is, can you expunge that old lien on residential property in Illinois? And the answer to this one is for a limited time, you will have that opportunity. What has happened here is through an amendment to both the Counties Code and the Mechanics Lien Act, the legislature has created a 3-year pilot program, which started on January 1st of 2019 and will expire on January 1st of 2022, absent any additional action by the legislature. And this enables the recorder of deeds in any county to establish an administrative law process to adjudicate and remove expired liens on residential properties. So if the recorder follows the process created by the county's code, the petitioner or the recorder, his or herself, can actually act as an interested party under Section 34 of the Mechanics Lien Act to require that the lien holder initiate suit or forego its lien. Or in an administrative process, a petitioner can prove by clear and convincing evidence that the lien has expired, and the administrative law judge can rule that the lien is forfeited and no longer affects the chain of title. So one way that this may be proven is a lien, for example, may be expired because on the face of the lien, the date that the work was completed was more than 2 years ago, and the lien claimant has not initiated a lawsuit in order to enforce that lien. So under the Act, that lien has expired, and under this pilot program, what we would call a stale lien, a lien that had been out there for more than 2 years, could be extinguished from a residential property. Additionally, in the residential world, the Home Repair and Remodeling Act Consumer Rights Brochure now must contain a full explanation of the homeowner's rights to obtain a sworn statement and lien waivers from subcontractors. So a contractor performing work on a resident-occupied property already has the obligation to provide the consumer rights brochure. Now that consumer rights brochure must also include a notification with respect to Section 5 of the Mechanics Lien Act that explains to the homeowner that the contractor must identify all subcontractors working on the property and the amounts that are owed or going to be owed to each, so that the homeowner may obtain lien waivers from those subcontractors before making payment to the contractor. Other than this change to the brochure notification requirements, this amendment did not change the substance of either the Home Repair and Remodeling Act or the Mechanics Lien Act. Turning now to Iowa, the legislature made several changes to the Mechanics Lien Act and the public project law in Iowa. The first thing the legislature did was it repealed a very old statute that was actually written in 1851 called the anti-collateral provision that was in its lien law. The anti-collateral provision disallowed mechanics liens where a subcontractor or material provider had obtained some sort of separate guarantee or other form of collateral from the owner. This significantly impacts material providers in particular. The Iowa legislature decided that the rationale for the anti-collateral provision was outdated, and the repeal brings the Illinois mechanics lien law into uniformity with most other states' lien laws. The mechanics lien law in Iowa was also changed to now permit a lien holder to amend the amount of its liens without first seeking court approval, provided that the lien holder is reducing the amount of the lien. This change allows a lien holder to maintain its priority without having to incur additional court costs to seek approval every time a partial payment is made on a debt secured by the lien. And finally, in Iowa, the Iowa legislature also made a change to the Public Projects Act, which now requires all subcontractors within 30 days of commencing work on a project to provide its notice to the principal and general contractor. Failure to do so will prohibit the subcontractor from being able to follow the procedures to record a lien with respect to that public project. However, there is an exception for constructions of highway, bridges, and culverts. In Missouri, in the case of Bray versus Sexton, the Missouri Court of Appeals reversed a trial court's dismissal of plaintiff's petition to enforce a mechanics lien on statute of limitations grounds. In its decision, the court clarified that when a mechanics lien commences pursuant to the statute is at the filing of the petition. So in this case, there was an issue about when the actual commencement of the action took place, and the court ruled that there is no requirement to actually have a summons issued, that the mere filing of the petition constitutes the commencement of the action for the purposes of determining the statute of limitations. And finally, in Ohio, the appellate court ruled that a mechanics lien must be supported by valid evidence, and that the amount of the lien could not be established by the lien holder's affidavit alone. So the appellate court reaffirmed that a party seeking to prove the validity of its mechanics lien in a foreclosure action has the burden to, quote, establish the reasonable value of labor and materials furnished, end quote, and cannot rely solely upon the mechanics lien affidavit. In this case, summary judgment at the trial court level had been granted for the plaintiff and an intervening plaintiff on the grounds that they had supplied affidavits in support of their mechanics liens that established the amount that was due and owing to them. In response, the defendant provided some answers to interrogatories that the plaintiffs had provided, as well as their own affidavits with respect to the value of the work that was provided. And the appellate court found that this was enough to create a question of fact. And for those reasons, the summary judgment was reversed and the case was remanded for further proceedings with respect to the value. So the takeaway here is that the plaintiff cannot rely solely on its own statement of the value of the work provided in Ohio, that it must be proven with evidence at trial, as long as there's a question of fact that's been created by the defendant. And that concludes the summary of mechanics liens. I'll now turn it over to Corey, who's going to talk about the statutes of limitations.
Good morning. Corey Newmeyer here from the Phoenix office of Quarles Brady. Let's see if I can. Oops. Get this slide to move. Oh, these. All right, I thought I'd set the stage with a quick review of the difference between statute of limitation and statute of repose. Statute of limitations set a lawsuit filing time limit based on when the potential plaintiff suffered harm. The discovery rule often, but not always, applies here. Statutes of repose set a deadline based on the mere passage of time or the occurrence of a certain event that doesn't itself cause harm or give rise to a potential lawsuit. The discovery rule rarely applies in this instance. So now we're going to turn to some Ohio case law developments. This past year, the Ohio Supreme Court in TSB Holdings LLC versus Board of Adjustment for the City of Iowa held that a developer's cause of action based upon a court judgment runs from the date the cause of action accrues, overruling its prior decision from the year before in Dakota, Minnesota, and Eastern Railroad versus the Iowa District Court. The Iowa Code provision at issue in these cases was Section 614.1, subsection 6, which provides that causes of action founded on a court judgment may be brought within 20 years after the cause accrues. In 2017, the Iowa Supreme Court held in Dakota that the 20-year statute of limitations on enforcement of judgments commences once a judgment is entered. The underlying dispute in the Dakota case dates back to 1872, when a railroad company built a bridge to allow railroad tracks to cross over a natural stream known as Whiskey Creek. Over the years, much litigation had occurred concerning whose responsibility it was to maintain drainage under the bridge, as well as maintain a dike that directed the flow of the creek toward the bridge channel. Eventually, in 1977, an Ohio court entered judgment against the then owner, requiring it to reconstruct and maintain the dike in order to channel the creek under the bridge. Several owners later, in 2013, a drainage district initiated a contempt proceeding against the current owner of the railroad right-of-way and bridge for failing to maintain that dike in good and proper repair, in purported violation of that 1977 permanent injunction. Among the various defenses the current owner raised was their assertion that under Section 614.1, subsection 6, the 1977 judgment had expired in 1997, which was 20 years after entry of the judgment. Overlooking the accrual language in Section 614.1, the court in Dakota concluded that the 20-year period commenced when the judgment was entered. Thus, the Iowa Supreme Court concluded that when 20 years have passed from the entry of an injunction, a contempt proceeding to enforce the injunction is barred by the statute of limitations unless the injunction has been renewed. In 2008, 2018, however, the Ohio Supreme Court once again considered a case in which Section 614.1, subsection 6 was at issue. In TSB Holdings, relying on a 1987 court order, developers sought the right to build apartments on certain adjoining properties they owned in Iowa City. After the city denied their site plans, the developers brought separate actions against the city and its Board of Adjustment. The properties at issue in the lawsuit were 6 lots located in Iowa City. These properties had been the subject of a former Iowa Supreme Court decision in 1987 styled Kemp versus City of Iowa City. At the time the original developer purchased the land, the city had zoned the properties to permit office buildings and high-density multifamily residential housing. While the original developer completed construction of an office building, the city revoked the developer's building permit due in part to neighborhood protests before all the development had been completed. So the original developer sued. The Iowa Supreme Court held the city's application of rezoning to the original developer's lots was unreasonable. The court then issued an injunction preventing the city from prohibiting the use of the property by the original developer for development or redevelopment as noted in its decision. On remand, the trial court entered an order which held that the original developers and their successors and assigns were permitted to develop the properties with apartments in accordance with the zoning provisions in effect in May 1978. All parties, including the city, approved this language before the trial court entered the decree. After entry of that remand order, the developer constructed a 12-unit apartment building on part of one of the lots. However, as to the remaining lots, the original developer did not do any further development. Over time, the original developer sold all of the properties, and eventually a new developer owned or controlled all of the lots that were the subject of the Kemp litigation and remand order. Approximately 25 years later, the city amended its zoning plan and designated, among other areas, the property at issue as single-family and duplex residential property. The city also rezoned the property to comply with its comprehensive zoning plan. However, before this new ordinance was published, the current developer submitted a site plan to obtain the city's approval for development of the lots, which the city denied on the ground that multifamily dwellings, i.e. apartment buildings, did not comply with the existing rezoning. So the district court ruled against the current developer in both actions. The developers appealed, and while that appeal was pending, the Ohio Supreme Court issued its Dakota decision. Relying on Dakota, the Court of Appeals affirmed both judgments from the district court on the ground that enforcement of the 1987 order was barred by Iowa Code Section 614.1, subsection 6. Following that decision, the developer sought review from the Ohio Supreme Court, which it granted. Iowa Supreme Court, my apologies. Although the Supreme Court addressed several issues in its TSB Holdings decision, I focus now only on the analysis of the Iowa Code section. The court began with an examination of its Dakota decision, wherein it acknowledged that it had failed to consider the accrual language of the statute. Given the accrual language in Section 614.1, the Supreme Court concluded it erred in Dakota in treating that section as a statute of repose as opposed to a statute of limitations, and that actions based upon a court judgment run from accrual of the aggrieved party's claim, which is not necessarily the date of judgment entry. Rather, in the case of an injunction, the accrual date may be the date when the injunction is actually violated. Accordingly, the court overruled Dakota, and with Dakota overruled, the court held that the new developer's claims were not time-barred. The new developer's cause of action accrued in 2013 when the board denied a variance and the city's new ordinances interfered with the developer's rights. Switching now to Minnesota, effective May 9th, 2018, Minnesota amended its statute of limitations for defect claims to clarify that the 2-year period of limitations cannot begin to accrue earlier than, quote, substantial completion, termination, or abandonment of the construction or the improvement to real property, end quote. Before the amendment, and still today, the limitations period does not begin to run until the injury is discovered. However, with this amendment, even if the defect is discovered before substantial completion, the 2-year limitations period will not begin to accrue until after substantial completion. All right, now we're moving to Ohio. In the past year, 2 Ohio appellate courts issued decisions on whether the construction statute of repose, Ohio Revised Code 2305.131, barred contract claims arising from construction defects. The 3rd District and the 5th District came to differing conclusions, but the parties to the 3rd District Court of Appeals case have actually appealed that decision to the Ohio Supreme Court, which accepted the appeal. So perhaps we will have the Supreme Court's pronouncement on this matter later this year. But first, some background. So prior to April 7th, 2005, Ohio Revised Code Section 2305.131 provided that no claims for any injury to property, real or personal, for any bodily injury or wrongful death arising out of the defective or unsafe condition of an improvement to real property shall be brought against any person more than 10 years after the performance or furnishing of such services and construction. This had been construed as a 10-year statute of limitations on construction defect claims in the Costco opinion from the Ohio Supreme Court back in the 1980s. I'm not sure I would necessarily agree with that construction because the time limitation is pegged to an occurrence of a certain event that doesn't cause itself harm, but we'll see where they go with that. In any event, in 2005, the Ohio General Assembly enacted a new version of 2305.131. So it restyled the prior version of the statute such that there is no question it is intended as a statute of repose. And under the current version, construction defect claims may not accrue later than 10 years after substantial completion. Substantial completion, by the way, means the date the improvement to real property is first used by the owner or tenant of the real property, or when the real property is first available for use after having the improvement completed, whichever occurs first. The new version of the statute is enacted in April 2005. April 7th, 2005. So, and I also put up there that Ohio has an 8-year statute of limitations on contract causes of action, which is relevant here in just a moment, but that begins to run when the action accrues. Prior to 2012, that was a 15-year statute of limitations. So in 1986, the Ohio Supreme Court issued its decision in Costco. Archbishop Costco had filed suit against an architect, general contractor, and subcontractors for breach of contract resulting from construction of a church roof that leaked from the day the church was first occupied. Construction was substantially completed October 25th, 1970, and then just over 10 years later, on November 6, 1981, the lawsuit was filed. The trial court granted summary judgment in favor of all defendants, finding the claim barred by the statute of limitations. The Court of Appeals, however, reversed, holding that Revised Code 2305.131 applied only to an action sounding in tort. Because the action sounded in contract, the 15-year statute of limitations applied, and therefore the claim was not time barred. The opinion, authored by Justice Cliff Brown, in which 4 other justices concurred, affirmed the Court of Appeals and held that the statute applies only to actions which sound in tort, and that actions in contract remain governed by the 15-year statute of limitations. In a rather terse analysis, the Supreme Court reached this conclusion based on the language used in the statute. Perhaps overlooking the full language of the statute, the Supreme Court characterized it as a statute of limitations. And according to the Supreme Court, the language used by the General Assembly, i.e. arising out of the defective or unsafe condition of an improvement to real property, was uniformly used to describe tortious conduct, and the use of those words distinguished the actions contemplated by the statute from warranty or other contractual claims. Notably, 2 justices dissented. In their view, the statute did not distinguish between contract, tort, or other forms of action, and rather referred to any actions according to the nature of the claimed injury, regardless of whether they sounded in tort or contract. And they would have found that the claim fell squarely within the statute. Almost 20 years later, the General Assembly enacted the revised version of RC 2305.131, which remains in effect today. However, between 2005 and 2017, there were no appellate level decisions in which the scope of the revised statute was at issue. Then in 2017, along comes New Regal local school district decisions. In 2015, New Regal initiated a lawsuit against an architect, a general contractor, and subcontractors. The complaint alleged breach of contract claims against the various defendants due to an alleged construction defects that purportedly caused several issues with a K-12 school facility that had been constructed 11 years prior. The defendants had contracted to provide various construction and design services in connection with the construction of the new school facility. And the complaint alleged the general contractor, roofing contractor, and architect had failed to perform in accord with professional standards. All of the defendants moved for judgment on the pleadings, claiming that the claims were time-barred by the statute of repose. The trial court agreed and granted judgment in their favor, and New Regal appealed. The third district reversed the trial court's decision on appeal, holding that the construction statute of repose does not apply to claims for breach of contract based on the Ohio Supreme Court's holding Cosico. Notably, the third district believed that the plain language of the statute did not support its conclusion, but felt constrained to interpret the language as applying only to tort claims because the current version of the statute contains similar language to the prior version, and the Ohio Supreme Court had previously held that such language only applied to bar tort claims. As mentioned, the defendants all appealed that opinion to the Ohio Supreme Court, and there will be oral argument on that on March 5th, just a few days from now. In another case, State v. Carl Roher Associates, the Ohio's 5th District Court of Appeals held that RC 2305-131 may bar breach of contract claims. In the early 90s, Carl Roher Associates signed an agreement with the Ohio Department of Administrative Services to provide design services related to structural engineering and related supervision for the construction of a garage in New Philadelphia, Ohio. After completion of the garage, issues with the garage windows started surfacing in 1997, and later other structural issues were discovered. In March 2015, more than 10 years after the building was substantially complete, the state filed a lawsuit against Roher for negligence, breach of contract, and declaratory judgment. Roher sought to dismiss those claims as barred by the construction statute of repose, which the trial court denied on the basis that the statute did not appear to apply to the state under the doctrine of nolum tempus. The case proceeded, and prior to trial, the state dismissed its negligence and debt claims. At trial, Roher moved for a directed verdict based on the statute following the close of the state's presentation, and the trial court found the claim founded in tort and that the state failed to present evidence that Roher had breached the contract and directed a verdict in favor of Roher. Both parties appealed. The Fifth Circuit only took up one assignment of error, which is whether the trial court could have granted the motion for judgment on the pleadings because the state's cause of action is barred by the statute of repose. The Fifth Circuit answered that question in the affirmative. In doing so, it found that the Ohio Supreme Court's Cosico opinion was not binding authority, that the current version of RC 2305-131 applies to claims that sound in tort or contract, and that the doctrine of nolum tempus does not prevent application of the statute to the state. With respect to Cosico, the Fifth Circuit observed that the Supreme Court had construed a prior version of the statute to be a statute of limitations, but it found persuasive the dissenting opinion in Cosico, wherein the dissenting justice had found the plain language of the prior version encompassed all actions, whether in tort, contract, or other forms. So relying on that precedent, as well as other Ohio Supreme Court precedent that changes to statutory language may cure ambiguities and also supersede prior court holdings, the Fifth Circuit went on to find that a change in the statute of repose language from no action shall be brought to no action shall be accrue, coupled with the legislature's pronouncement that the statute would apply regardless of prior law, the Fifth Circuit found that Cosico was no longer binding authority, and that by its interpretation, the claims were barred whether they sound in tort or contract. There was no appeal of this, which makes the decision the most recent pronouncement on the application of Ohio's construction statute of repose. However, as mentioned, the Ohio Supreme Court will be weighing in on this under the new Regal case in the near future. Thank you.
Thank you, Corey. And now we'll send it over to Natalie Thomas in Tampa to talk about insurance.
Good Good afternoon. This is Natalie Thomas. I am a construction litigation attorney in the Tampa, Florida office of Quarles Brady, and I'm going to be speaking today about the insurance law updates for the Midwest. Mainly, it's mainly case law updates. There hasn't been anything really earth-shattering or new in the insurance space in the Midwest this past year. It's been a lot of interpretation issues that the courts have gone over and pretty much reinforcing the way that they interpret contracts. The first, we'll go to Illinois first and talk about some cases that have come out of Illinois this past year. The first one is LB Steel LLC versus Quarles Steel. This was basically the court interpreting a contract insurance policy provision. It revolved around a construction project at O'Hare Airport. There was a general contractor at the center of the dispute. That general contractor contracted with the city of Chicago, and the project was basically, it encompassed many things, but one of the key aspects for this case was that they were to construct several steel canopies for the airport. The general contractor, in furthering this steel canopy work, hired a subcontractor to perform the work. That subcontractor hired a fabricator for the steel, and that fabricator in turn hired an engineer that was to design these specific canopies. As part of its contract obligations with the city, the general contractor obtained both a bond and an insurance policy from Zurich. The insurance policy at issue here contained coverage for negligent acts, errors, and omission of design professionals, that it was specific in that it was design professionals for whom the general contractor was legally responsible. It excluded specifically coverage for faulty workmanship in the construction, manufacturing, or materials. A dispute arose, as it usually does, over the canopy, and particularly the welding of the canopy. There's lots of finger pointing between all of the different parties. And while that was going on, the general contractor made a claim under that Zurich policy for the damages that it was incurring in the project. Zurich ended up paying the general contractor $8 million under that insurance policy for various design errors. Those design errors were not related to the steel fabrication. There was a later lawsuit between the fabricator and the general contractor, and the fabricator was ordered to pay $27.5 million to the general contractor because it was found to be at fault for the defects in this canopy and the welding. The fabricator turned around and they wanted to offset the $8 million award that, or the $8 million payout that the GC got from Zurich against their judgment. The court found that there was no offset here. The fabricator wasn't entitled to the $8 million because the amount paid to the GC under the Zurich policy were not related to the steel fabrication. The court also looked at the policy and looked at the plain language of the policy and determined that it only covered failures by design professionals for which the general contractor was responsible. Here, this was a fabricator for the sub-manufacturer, or I'm sorry, it was a design professional for the sub-fabricator. So it was not someone for whom the general contractor was legally responsible for. The court went over a lot of the rules of construction, and basically, as is the court has done, rules of construction for insurance policies follow rules of construction for contracts. The primary objective, the court noted, was to ascertain and give effect to all of the provisions in the contract, and to look at the plain language of the policy, looking at the policy as a whole. And the court also went to great pains to note, that if possible, they want to give effect to every provision in the contract. And extrinsic evidence, the court said, is only considered when the policy language is ambiguous. If it's unambiguous, the policy is applied as written. The court found here that the policy was clear and unambiguous as written, so the court went ahead and denied the requested set-off. Indiana, the only change that was of note in Indiana was a Senate Enrolled Act number 290 that changed the civil penalties for an employer's failure to provide proof of workers' comp coverage. And that change was that the penalty went from $50 per employee to $100 per day. Moving over to Missouri, the first case that came out was the American Family case out of the appellate court in Missouri. This was another case, not breaking new ground necessarily, but demonstrating again how the courts interpret provisions, and here how they look at the common usage of undefined words and phrases in those policies. A little of the background of this case: it was homeowners sustained losses. They, in connection with the construction of an observatory that they wanted added to their house. The observatory was supposed to have a telescope in it, so they had to build a telescope support system, and that involved installing piers and pouring concrete over those piers. The homeowners claimed that the concrete was poured incorrectly and damaged not only the piers, but the rest of the telescope support system and the foundation of their home. So they looked to their own insurance policy for coverage for the damages and for the loss of use of the observatory. The insurance company, their insurance company failed to pay them, and so the homeowners brought a claim against them for breach of contract and for vexatious refusal to pay the claims. The court basically focused on two provisions of the policy. One was the policy's exclusion for faulty construction, and the second was the exception to that exclusion for resulting loss. The court again went over, the court's challenge here was to harmonize those two provisions so as to basically give them both a reasonable meaning. And so while the court said that while faulty construction exclusion, while that exclusion excluded coverage for losses caused by faulty construction and would seem to exclude the coverage for the construction of the support system here, the resulting loss clause had to be considered in the context of the whole policy. And when that was done, it reinserted coverage for these particular losses. And again, the court looked to the rules of general contract construction, giving plain meaning of words, their ordinary meaning that an average person would understand if an average person was purchasing this insurance policy. The terms, again, the court said would be those that would be defined by a layman who was purchasing this policy unless they were specifically defined in that policy. The court also talked about undefined terms and giving them the ordinary meaning as a dictionary would supply, and it looked at its terms. Again, it looked at the layman standard of an average person and gave the meaning to those terms. Oops, I'm sorry, keep going the wrong way. Here, the only way that the court found to give both the faulty construction exclusion and the resulting loss exception meaning was to find coverage for damages resulting from an excluded loss, which is what we ended up having here. For their loss of use claim, the court denied that claim, saying there was no coverage because the policy covered loss of use only when the premises was rendered uninhabitable, and that was not the case here. They just weren't able to use that addition where the observatory was going to go. With respect to the vexatious refusal to pay claim, the court looked at this and talked about the way to obtain a penalty for an insurer's vexatious refusal to pay is the claimant must show that the refusal was willful and without reasonable cause or excuse to a person at the time that the insurer asked for the coverage, not later when it's determined by the court, but at the time when the coverage is requested. So here, there was no cause of action because the insurer had a meritorious defense to the coverage claim. Another case coming out of Missouri was View Homeowners Association versus Burlington Insurance. It was basically discussing a CGL policy and the scope of damages for a negligent renovation. This was one of a few cases where the court basically said, you know, that CGL policies are not catch-alls. The court noted here that this policy didn't cover construction defects resulting from a negligent renovation, and that this type of coverage isn't a guarantee of the quality of an insured's product or work. It's not intended, the court noted, to protect the business owner from every risk of operating the business. The court also took a look at the duty to defend, which was broader, it noted, than the duty to indemnify, and talked about when the duty to defend arises, and the court made the determination that that duty arises when you look at the policies and then you look at the facts alleged and the facts the insured knows at the outset of the case. If and if it implicates the policy, then there's coverage, and the duty to defend arises. If, in order to get out of the duty to defend, an insurer must prove that there was no possibility of coverage for claims under the policy. The next case, Rice Painting Company versus Depositors, also looked at the duty to defend. It was basically, the court made the broad statement at the end that I have there that, although Missouri law does like to find in favor of coverage, there has to be, it's not rendered boundless. That the duty to defend is not boundless. The last case out of Missouri was Depositors, Inc. versus New Construction Services. Again, the court found no duty here to indemnify. And this was one where it was a little bit different, where the contractor failed to adequately notify the insurer of the owner's demand for arbitration until after the judgment was final. So basically, they didn't tell them that there was even a claim until after they got a judgment back from the arbitration. The court found that even though the burden was on the insurer to prove prejudice, the court found prejudice here because the insurer was deprived of the opportunity to investigate, to defend, to settle, to determine strategy. The time for the appeal had even passed by the time that they got notice. And the court did make a distinction between the denial letters that the insurance company sent at the beginning of the entire dispute to the contractor and property owners. And the court held this didn't waive the notice requirement. And because of this prejudice for the failure to notify them, this insurance company was relieved of all the duties under the policy. Okay, moving to Ohio. Again, the court looking at a CGL policy, basically, indicating it is not a catch-all. This was for water damage, and it was water damage and mold damage. And the Ohio Supreme Court reaffirmed its holding from the 2012 Westfield insurance case, basically saying a CGL policy doesn't cover property damage caused by the owner's own faulty workmanship. Moving to Wisconsin, this was a case, waiver of subrogation. An insurance company was not allowed to maintain a subrogation count where the owner had sustained damages related to the construction of a barn, and the contract between the owner and the barn contractor had a waiver of subrogation, and the court held that waiver of subrogation precluded the subrogation action by the owner's insurance company. And the court looked at Wisconsin statute 895.447 and stated they found that was inapplicable, because there was no tort liability implicated here. So the subrogation provision was valid. The last case out of Wisconsin was Foley versus Wisconsin Mutual. Here, the homeowners hired a contractor to remodel a home. There was some black mold that was found on the ceiling, and the homeowner's insurer relied on a pollution exclusion that excluded the claim for mold. The court basically looked at the allegations in the complaint. The allegations in the complaint only discussed mold. It didn't discuss anything else, such as water damage, which could have arguably given them coverage. And the court held that there was no coverage based upon the scope of the allegations in the complaint. The last thing I want to mention very quickly is a few days ago, actually last Thursday, the Wisconsin Supreme Court came out with a new decision. That was in the case of State of Wisconsin versus, Circuit Court for Brown. And it was a very lengthy opinion. It was the Supreme Court issued a supervisory opinion where they vacated the underlying court-ordered stay of an arbitration of a private construction dispute. And basically what the underlying court was trying to do was decide an insurance coverage dispute between one of those contractors to the arbitration and its insurer. And the Supreme Court held that the Circuit Court lacked the authority to interfere in this private arbitration, and there was no basis to obstruct the scheduled arbitration over the liability claims pending the Circuit Court determination. And that is it. Thank you.
Thank you, Natalie. I'm going to speak about indemnity, and first is a case out of Michigan, in re Estate of Koch, and this is regarding the application of Michigan's indemnity invalidating law. And in this case, back in 2012, the Village of Dexter, Michigan entered into a contract with a designer and a general contractor for a wastewater treatment plant improvement project. The general contractor then entered into a contract with Platinum Mechanical for the labor and the materials. While the plant was under construction, a digester explodes and kills Michael Koch, who is an employee of Platinum, the subcontractor. Koch's estate, of course, then sues the general contractor and the designer. The designer files a cross-claim against the general contractor and a third-party complaint against Platinum. The gist of the lawsuit was the designer alleged that the various parties or contracts between the parties required the general contractor and the Palladium to indemnify the designer, even if the designer was solely responsible for Koch's death. General contractor and Platinum obtained summary judgment based on MCL 691-992-1 sub 2, which is Michigan's indemnity invalidating law, which prohibits indemnification provisions in construction contracts that purport to indemnify indemnities for their sole negligence. In relevant part, the statute reads as follows. When entering into a contract with a Michigan licensed architect, professional engineer, landscape architect, or professional surveyor for the design of a building, or a contract with a contractor for the construction of any such improvement, a public entity shall not require the Michigan licensed architect, engineer, landscape architect, or professional surveyor or the contractor to defend the public entity or any other party from claims or to assume any liability or indemnify the public entity or any other party for any amount greater than the degree of fault of the Michigan licensed architect, etc. In other words, the indemnitor is only required to indemnify to the extent of its own negligence. Based on the plain language of the statute, particularly the fact that it purports to govern actions taken at the time of entering into the contract, because again, it starts with when entering into a contract with a Michigan licensed architect, etc. The Court of Appeals concluded that the statute does not apply retroactively and that the trial court erred in granting summary judgment because the contracts were entered into in 2012. So if you practice in Michigan, it may not be the case that you ever have a client who has an issue with an indemnification provision in a construction contract that was signed and executed prior to 2013. But if that ever does come across your desk, this is a good case to be aware of. Next is a case out of Wisconsin, where the Wisconsin Court of Appeals interpreted an indemnity clause, and I think it's instructive. The case is Lucero versus Amerisure Insurance Company. And in that case, Verizon Corporate Services Group, which is the procurement arm of Verizon Wireless Altel, had contracted with a general contractor, McShane Construction, to renovate a building that Verizon Wireless Altel owned. The construction contract did not mention the owner, Verizon Wireless Altel, but it did require the general contractor, McShane, to indemnify Verizon Services and its quote-unquote affiliates, and the contract also included a provision that purported to give other quote-unquote Verizon affiliates the power to enforce the contract. While construction is ongoing, an employee of a drywall subcontractor gets injured and sues the owner, Verizon Wireless Altel, which then, of course, demands indemnity from McShane pursuant to the construction contract. Both parties filed for summary judgment on that claim, and the trial court rules for the general contractor, finding that Verizon Wireless Altel had failed to establish that it was a quote-unquote affiliate of Verizon Services such that it could properly avail itself to the protections afforded by the construction contract's indemnity provision. On appeal, the Wisconsin Court of Appeals reverses and finds that issues of fact preclude both McShane and Verizon Wireless Altel from obtaining summary judgment. The court focused on the definition of affiliate, which was defined as any corporation, partnership, person, or other entity that directly or indirectly controls or is controlled by or is under common control with the first entity. The court then looked to the contract's definition of control, which was defined as the possession of power to direct or cause the direction of the entity's management and policies. What had happened was, in support of the summary judgment briefing, Verizon Wireless Altel had submitted affidavits from its officers that basically stated that Verizon Services is a wholly owned subsidiary of Verizon Wireless Altel, but those affidavits said nothing about Verizon Wireless Alltel's ability to control Verizon services. So, because the definition of affiliate hinged on control, and because Verizon Wireless Alltel had failed to submit evidence of control, the Court of Appeals found an issue of fact existed regarding if Verizon Wireless Alltel was in fact a quote-unquote affiliate for purposes of the construction contract's indemnity provision. And the practice pointer here is fairly obvious, I think, which is when you're drafting indemnity provisions, be specific. If you know the name of the entity or individual that is likely to be the target to get sued if something goes wrong, make sure that entity or individual is actually named in the indemnity clause. Here, Verizon Services should have known that as the owner, Verizon Alltel would be the target, so Verizon Alltel should have been specified as an indemnity in the agreement as opposed to a kind of roundabout way of defining them as an affiliate. Lastly, I have another case out of Wisconsin, and this is an interesting case and instructive as it relates to indemnification provisions. This is American Family versus Cintas. It was not a construction case. It arose out of a contract between a property management firm, Becker, and Cintas, which was an entity that Becker contracted with to perform certain services, which included inspecting fire suppression systems. The fire suppression system in the building burst and it caused property damage, at which point the owners sued Cintas, who then sought indemnification for its own negligence from Becker pursuant to an indemnification provision in the party's contract. Becker rejects the tender and Cintas sues. In defending the lawsuit, Becker primarily argued that the indemnification provision was unenforceable for two reasons. First, Becker argued that in violation of SPIVI, which is the seminal case on how a party can obtain indemnification for their own negligence, the indemnity provision failed to contain a specific and express statement whereby the indemnitor, again Becker, agreed to indemnify the indemnity, which was Cintas, for Cintas's own negligent acts. And second, Becker argued that the provision was not sufficiently conspicuous in violation of Demansky and WISSTAT 401-201-2F. Demansky is a seminal case regarding indemnification provisions and conspicuousness, and it basically says that indemnifications must be conspicuous to be enforceable. And the cited statute is part of Wisconsin's commercial code, and it actually defines conspicuous. The statute reads in part that for a term to be conspicuous, it must include either one, a heading in capitals equal to or greater in size than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same or lesser size, or two, language in the body of a record or display in larger type than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same size, or set off from surrounding text of the same size by symbols or other marks that call attention to the language. Now, the majority in this case actually found there was a choice of law provision that said Ohio law governed. They applied the Ohio law choice of law provision, interpreted the indemnification clause under Ohio law, and said based on Ohio law, it is in fact enforceable. What's interesting about this opinion, though, is not the majority's opinion, it's the dissent's opinion. The dissent in the first instance opined that the majority erred in applying Ohio law. The dissent thought that parties are free to include choice of law provisions in their contracts, but Ohio law does not mandate that indemnity provisions be conspicuous along the lines of the requirements in Wisconsin. So the dissent reasoned that it was against public policy for Ohio law to apply to this provision in the first instance. And then the dissent went on to provide a roadmap for drafting an enforceable indemnity provision. And they basically went through the latest and greatest statements of Wisconsin law with respect to drafting those provisions. And I think the takeaways from this case are to consider choice of law provisions carefully. The majority here wasn't concerned with public policy, apparently, but the dissent makes a compelling point. And given the right case, I could see the court choosing to ignore a choice of law provision to avoid enforcing an indemnification clause that would otherwise be prohibited under Wisconsin law. Another takeaway is, with respect to drafting these provisions, clearly define the scope of the indemnity. And lastly, be sure to comply with the mandates of Wisconsin's commercial code and Demansky with respect to conspicuousness. And With that, I'll turn it over to Eric Van Scandal in Milwaukee to talk about public procurement.
Thanks, Michael. And as Michael said, I am with our firm's construction law and real estate and do government procurement in both Milwaukee and our Minneapolis offices. And I want to touch upon, since we've only got a little bit of time, a couple of the issues that frankly have been highlighted earlier too, but touch upon public procurement issues. One is prevailing wage, and it continues to be the case that almost every year we're reporting on a new Midwestern state that has repealed prevailing wage requirements. And the import on this is whenever you're going to be bidding, if you're a contractor and you're going to bid a job, you got to make sure you know for price purposes what state you're in and whether or not things like prevailing wage will apply. And Michigan now is one of those states that it will no longer apply. Missouri is also a state now that's somewhat limited the application to only projects that are in excess of $75,000. But don't forget that if you are doing a federal project in either of these states or in Wisconsin, for example, that repealed last year, you still will have a prevailing wage requirement on your contracts. Getting paid is always an issue with both public and private projects. And Illinois, we had an interesting case that Natalie spoke about a moment ago, and I just wanted to highlight one small part on that and two different things. When you have public projects in states, typically you have two different ways that a contractor or a subcontractor is going to try and get paid. One is via a bond, or another one is doing a lien on funds held by the public entity. As Natalie talked about earlier, in the LB Steel case, which dealt with the O'Hare reconstruction, one of the subcontractors attempted to put a lien on public funds that were still to be paid to the prime contractor. But what they hadn't done is they had failed to substantially perform their contract in a workmanlike manner. And it is case law in Illinois that you have to do so in order to be able to actually maintain that lien on public funds. And in this particular circumstance, they did miles and miles and miles of welds, and only a small portion of those welds were failing. However, they were still significant, and the court found that to be satisfactory. Iowa, the interesting change that Charles spoke about earlier is a change in terms of notice by subcontractors to the prime contractor as it relates to bonding. Now, this is what's called the Little Miller Act in Iowa. There's also the Big Miller Act, which is a federal law. And the Miller Act and the Little Miller Acts all require that bond I talked about earlier that prime contractors have to put up, and that in many ways guarantees subcontractors and subcontractors to get paid. Importantly, the Miller Act, again, this is the federal law, requires notice to the prime contractor by subs within 90 days of the last date of furnishing work. Iowa does it totally different, and that is you have to provide that notice within 30 days of starting work. So the important takeaway there is A, know where you are again, and B, make sure that you provide the notice and know when your notice needs to be provided. There's also public entity protections that came up in a couple different issues this last year. In Michigan, Mr. McCann spoke about this just a moment ago, and it's dealing with the indemnity invalidating law. And the interesting takeaway on this particular issue is states don't always get it right. And you want to make sure that you read the contract that you're dealing with, and you may even have a contract provision that is in fact void because of law. And make sure you deal with an attorney that's in your particular jurisdiction to make sure that you are don't have any protections you're losing. In Iowa, there's the state of art immunity protection for municipalities. Municipalities, not shockingly, are immune for tort liability if they have a negligent design and there's some kind of tort issue that flows from that. And that is if they actually adhere to what's called the state of the art at the time they constructed it. In the Kellogg case, a house was built about 10 years after a stormwater pipe was put in. That pipe shot directly at the house, yet someone still built a house there. The plaintiff bought the house in 2008 and then immediately started complaining that their basement was flooding. The question was whether or not, in that case, was whether or not nuisance falls within the immunity protection, and previously it was just negligence. At the end of the day, the court wiggled around with the statute to be able to say that nuisance is still going to be based upon negligence and therefore also falls under the protection for the municipality. So that goes to the idea that you, again, need to be paying attention to what protections a municipality may or may not have, both under contract and also common law when you're dealing with them. Finally, we have what's called the spearing doctrine. And this one's really important both for governmental entities and also contractors to be aware of. And that is, what are you looking at for the specifications that you're getting from the government or the government's giving to someone at the very beginning of a project? Is it going to be what's called a design specification or a performance specification? The Spearin case dealt with a dry dock in the Navy Yards in Washington, D.C. And the government ended up giving the contractor there what's called, again, design specifications that said, you have to build it exactly as X. They gave them a roadmap. And it was built to that roadmap, yet there were still problems. That's a protection for the contractor that if they follow the design specifications to a T, they are not at fault for any defects that arise from the unknown issues. Michigan deals with it just a little bit differently. They don't have a distinction between design and performance specifications. Instead, the question there is whether or not the municipality or the governmental entity had information that they didn't disclose, and typically didn't disclose it as part of the specifications. The previous case law in Michigan would hold against a governmental entity if, again, they had relevant information that wasn't disclosed. But here in the Rainbow Construction case, the Township of Howell had information, didn't have information. They didn't do additional borings in soil, and so they didn't know whether or not there was a problem underlying the subsurface issue. And the court ended up protecting the Township of Howell because of the fact that they didn't have that information. And at the end of the day, the law does not require that a party soliciting bids to disclose pertinent information in hand. They do not have to acquire additional information. They just have to disclose what they do have. With that being said, I will turn it back over to Michael to close us out.
Thanks, Eric. We have not received any questions from the audience, and I see that we are out of time, and we certainly want to be respectful of everyone's time. We will circulate a Q&A sheet with the survey to the extent anyone does have a question that they would like to ask us. And that will conclude our 2018 webinar. Thank you so much for attending. We really do sincerely appreciate your time. Thank you.